And our first case on the morning docket is People of the State of Michigan versus Trevor McLeod, file 23-6748FH. Good morning, Mr. McLeod. And still your intention to represent yourself in this matter?
That's correct.
And Mr. McLeod, this is scheduled for a docket call, but also you filed a motion to reconsider the court's denial of the motion to suppress. I've reviewed your motion. Go ahead and say anything further that you wish to in its support.
I mean, I think it's pretty well laid out in my motion to reconsider.
Thank you, Mr. Juliet. People have a position? No. All right. Well, Mr. McLeod, I mean, your motion to reconsider is that this court doesn't have the authority to interpret the consent decree, and that you don't have to announce your status as a tribal member to DNR officers in order to be protected by the provisions of the consent decree. I mean, I'm assuming that those statements that you make are true, you know, but it's my opinion that doesn't change the ruling in this case, because if you were charged with some kind of boat registration violation or something,
Which I was.
those may well be. Well, but that's not the violation that's in front of me.
But that's the initial violation for the whole reason why I'm here.
Right. But if you were charged with that, this might well present a defense. But what I'm saying is that doesn't invalidate the officers having contact with you, because they have no idea who's who out there.
Right.
To accept your argument means that they just don't get to that tribal members could just go around and they don't even get to get stopped when the police don't even know who they are.
Well, I think this is because they're supposed to be trained to ask if we're tribal or not. Well, and in fact, in the consent decree, for them to even be qualified to handle or deal with tribal members, they're supposed to have cultural sensitivity training. And I can tell you right now that I've called my tribe and they're not on any list that's that has had that training. So they're not even qualified to approach or ticket or do anything with tribal members until they complete that training, and they've never done it. So,
well, the testimony was that the officer, immediately upon initial contact, did detect indications of impairment, and then
right. But I also proved that he perjured himself, which means his testimony is junk.
Right. So based upon his testimony, the stop was good, the investigation was good, and the motion for reconsideration is denied. So what that does, sir, I don't even know who you are, but you got to stop interrupting the process, right?
I'm sorry.
Okay. You can observe, but you can't participate. You understand there's a difference there. All right. So, Mr. McLeod, then you previously stated that it was your intention to file an application to appeal the Court of Appeals, or are you still seeking?
Well, currently what's going on is I'm filing a criminal complaint against these officers and probably a civil complaint. So I'm going to make a move to stay the court, motion to stay the court for a bit while I get these complaints going and get them to the right authorities.
Well, I'm not going to do that. I mean, it's one thing, you know, sometimes when people are appealing a ruling, that's different, but you're saying you want to pursue criminal or civil remedies against the officers. I don't even know what those would be. But I'm not going to stay in this case for that. Well,
I've also got 5 more motions that I've already written and I'm going to turn them to, so I need some time to sort this out.
Well, when are you going to file those? Here's the deal, like you should file all the motions you want me to hear, and then I can hear them. And then if they resolve the case, great. If they don't, then we'll set it for a jury trial. What we shouldn't ought to do is just kind of trickle them out so this case lasts, 2 years or something. So what I was thinking I could do today is give you a jury trial. But if you've got some more motions to file, I'll put it out for another docket call, but that'll be a motion cutoff, meaning that any arguments you got about this case, file them all, and we'll hear them all. Does that make sense?
I guess so.
Okay. So let's pick a date for that. What about April 23rd? It's in about 5 weeks. That should give you plenty of time to get your motions filed.
Yeah, that's right.
Okay. All right. So let's schedule this then for a docket call, and that'll also serve as a motion cutoff for April 23rd at 9 a.m.
I'd like to have Officer Liestenfelds and Beelman present for questioning. Could I have Officer Liestenfelds and Officer Beelman present for questioning?
Well, it depends on what motion you file.
It's going to have to do with their testimony.
Okay, so if you file a motion that requires the testimony of the officers, then how that generally works is when you file the written motion, then the prosecutors, on notice that in order to respond to that motion, they have to bring the officers to testify. What motion do you think you're going to file that requires their testimony?
Well, so in Mr. Liestenfeld's report, which you probably have in front of you.
I don't. I only get what you guys give me during motions.
I submitted it all. It's all in the clerk's file. But he states in his statement that once the warrant was signed, that I gave him my blood without cause, but in my documents, I've got an unsigned warrant. It was never signed. So his testimony will be impeached also. They're both lying.
Okay, so you're going to file a motion to blood test. Okay, and that would require the officer's testimony. So, all right. So yes, if you file a motion like that, Mr. Julia will bring the officers. Okay. Otherwise, he would probably lose the motion because it's his burden to come forward with that evidence then. All right. All right. Anything further today then, Mr. McDuff?
Oh, good enough.
Okay, we'll see you April 23rd at 9 a.m. All right. Your circuit court for the county of Sheboygan, and we are providing public access both in the courtroom and also online. First this morning, we've got People of the State of Michigan versus Trevor McLeod, file 23-6748FH. Counsel for the people, you want to state your appearance, please?
Anthony Julian, on behalf of the people.
All right, and Mr. McLeod, good morning, sir.
Morning.
Again, every time we come into court, I'm going to be required by the court rules to confirm that you wish to represent yourself in this matter without the assistance of an attorney.
That's correct.
All right. We're here for a docket call as well as several motions that you filed up, that you noticed up. One of them does require some testimony. That was the motion to suppress the chemical test results. Your filing the motion triggers the prosecutor's burden to establish that search was taken properly. Is there any opening statement you want to make, Mr. McLeod, about your motion to suppress the chemical test results? And you'll have an opportunity to argue after the testimony as well. Any opening statement you want to make?
Well, I just received an email from Julie Rattell. I don't know if she's a court administrator or clerk.
She works in the prosecutor's office.
Okay, I just received an email from her on Friday with the warrant that was never found in Discovery or anywhere. It just turned up Friday magically, I guess.
Okay.
So I'd like to open with that.
Okay, Mr. Juliet, any opening statement?
No.
All right, and your witness?
Conservation Officer Burgoyce.
All right, Officer Burgoyce, would you please raise your right hand for me, sir? Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Go ahead, Mr. Juliet.
Sir, can you state your full name and spell your last name for the record?
Alexander Bourgeois, Bourgeois.
Thank you. And where do you work?
I work for the Michigan DNR.
How long have you worked there?
I got hired in July. I've been working the field since August of 2022. So 2022.
Okay. Were you working on September 4th of 2023?
Yes, sir.
Okay. And did you have some interaction with the defendant, Trevor McLeod, that day?
Yes, sir.
Is he present in the courtroom, if you can see?
I can't see, but I saw him earlier. He's in the defendant seat.
All right. Can I let the record reflect that?
September 3rd.
Can I let the record reflect the officers identified the defendant?
Yes.
Thank you. Can you describe what caused you to have contact with him?
Initially on that day, we were doing a BUI patrol, and other COs notified me and the other officers that were in my patrol boat that there was a boat with expired registration. We went to the Forks boat launch to make contact with that vessel and subsequently, we found out that the defendant was intoxicated while he was operating the vessel, and that led to the arrest of him.
How did you find out he was operating while intoxicated?
Once he had exited the vessel, I noticed that he had to use the post on the dock for his balance to get out of it. He took off his sandals, then walked to the bathroom, and as he was walking, he stumbled and swayed back and forth along the dock and up the ramp of the boat ramp to the bathroom. And then the same thing coming back. Myself and other officers observed this, and that's when we made contact with him.
Okay. When you made contact with him, were there any other signs of intoxication that you could tell?
Yes, while talking to him, I observed slurred speech. When I asked him for his documents, for his boat and his driver's license, he lacked fine motor skills. I couldn't pick through the papers. That's a common sign of intoxication. And then when he was stepping into the vessel to go get the registration for the vessel, I noticed that it took him about 10 seconds just to put on one of his sandals. That would show that he was lacking fine motor skills, couldn't put his foot inside of the sandal to put it on.
Did you perform any standardized field sobriety tests?
No, sir, the defendant refused.
So what happened after he refused the field sobriety test?
Myself and Officer Listenfeldt, we advised him that he was going to be under arrest for BUI and asked him to exit the vessel that he was in. He refused, even though we gave him a lawful order. We told him that if he didn't exit the vessel, that additional charges would be brought against him, resist and obstruct. He still refused to. Officer Listenfeldt got inside of the vessel with him. We told him to place his hands behind his back, that he was under arrest. And Officer Listenfeldt went to grab his arms to put his hands behind his back. The defendant pulled away from Officer Listenfeldt. And during this time, a scuffle erupted and Officer Listenfeldt fell on top of the defendant. He put his arms in front of him so that way he couldn't be cuffed. During this tussle, Officer Listenfeldt was able to pull his left arm behind his back and put a cuff on it. And then the defendant still kept his right arm on his chest. At this time, I pulled out my taser. I took the cartridge off so that I could use the dry stun option. I had to tell him 4 times that if he didn't comply, he was going to get tased. And then finally, Officer Listenfeldt was able to pull his right arm behind his back and handcuff him.
Okay. So at some point, did you arrest him for boating under the influence?
Yes, sir.
And is there a procedure within the Department of Natural Resources for what to do when you arrest somebody for boating under the influence? Do you draw blood or do you use a data master or anything like that?
Yes, sir. It's the same as if it was a motor vehicle. Obviously, with how he acted, we knew that he was going to refuse. So once we got to the jail, the Sheboygan County Jail, Officer Listenfeldt read him his DI 177, which I think it might be called something else for DUI, but his chemical test rights. And then I started typing up the search warrant because we knew that he was just going to refuse. And then we went and got the search warrant for his blood.
Okay. Do you know if he actually refused or?
Yes, sir.
Okay. And you said you were the one that typed the search warrant?
Yes, sir.
Do you have a copy of the search warrant with you?
I have it about 10 feet away from me if you'd like me to grab it.
Sure, Officer Bourgeois, if you want to go retrieve that.
Okay.
I object to it. It is as exhibit. Just turned up on Friday.
Okay, well, it hasn't been offered just yet, but you're about to offer, right?
Yes.
All right, so the objection is that it was not provided during discovery.
I mean, 3 different requests for discovery.
In response to that?
I don't know. I mean, it's his motion to suppress the search warrant. I mean, I think I should be able to offer it as evidence.
Right. Well, I mean, do you have any response to the discovery objection that it wasn't provided, or?
I do. We didn't have the search warrant in our file. We had to call up to the jail last week and get it. So when we got it, that's when we emailed it to them.
Okay, that objection, Mr. McLeod, to be overruled. It's far in advance of trial. We haven't even set a trial date. We might end up doing that this morning yet, but we don't have a trial date.
So if we're allowed to keep bringing discovery, I'd like to allow my witnesses that I forgot to call for their discovery to be brought into the case also.
For what? For what purpose?
for the trial.
A trial? Yes, we haven't even, so if I set a trial date today, there'll be a deadline to file witness and exhibit lists. Okay, you'll be able to do that. Yeah, discovery's just got to be done well in advance of trial. And for purposes of responding to your motion today, then it's appropriate. All right, go ahead.
Officer, do you, can you recognize who's the magistrate or the judge that signed the search warrant?
The signature is in cursive, but it looks like the first name is Mariah and then Ellen Bowe. It's hard to read the last few letters of her signature, but it was a female that came in.
Okay. And what date was that search warrant issued?
9/3 of 2023.
If I can approach for people's proposed one, for admission of people's one.
All right, any objection to the admission of people's exhibit one?
It's invalid. It doesn't have any details. It doesn't have a charge. The affidavit that's supposed to go with it isn't signed by the judge or by the officer. And it's completely procedurally incorrect. I wasn't provided a copy or shown that warrant at the time of the arrest. I haven't had a copy in the 3 requests for discovery.
Okay, those objections are overruled. People's exhibit one is admitted.
May I continue, Your Honor?
Yes.
Officer, did you serve the search warrant on the defendant?
Yes, sir.
And where was that at?
It was at the Sheboygan County Jail.
Okay. And did you subsequently observe blood being drawn?
Yes, sir. Both myself and Officer Listenfels were in the room.
Any questions for this officer?
Yeah. So on the day that you were out on saturation patrol, could you explain what saturation patrol is?
So, yes, sir. So, what we're looking for is it was a busy time of the year. It's boating season. So, what we'll do is we'll put a lot of officers out, whether it's on the water or on land, that would be used for transportation if an arrest is made. But we look for BUI, anything to do with alcohol violations. So if we came across someone that was under the influence of boating, typically we either have officers that would take them to the jail for us, or that could go and patrol our area once we did that. But it's a large number of officers in the area specifically looking for BUI and safety issues with the boating season.
And all these officers have a pretty good training on the laws of OWI and have training on how to perform and execute these arrests.
Yes, sir.
Okay, so are you aware that according to the Natural Resources Environmental Protection Act, section 324-80176, subsection 3, that in order to approach anyone or board their vessels, if you suspect an OWI, the suspect has to be visibly impaired while underway?
Sir, you were underway. I think we covered this in the first motion you filed.
You never noted that I was visibly impaired while I was underway. In fact, you said that you did observe me through binoculars to see if my registration was expired. Is that correct?
Yes, I did use binoculars to see you underway with the vessel and that your expiration was expired, yes.
Okay, the reason why you approached me was the expired registration. Is that correct?
Well, we docked next to you to talk to you about the registration, but once we docked next to you, then we observed the signs of impairment, which even if you didn't have expired registration, I still would have made contact with you because of the reasonable suspicion of intoxication.
Okay, when you report, you state the reason you and your partner approached me and my family was due to an out-of-date registration. Is that correct?
That was one of the reasons, yes, sir. But again, we would have made contact with you regardless of the registration because of the stumbling and swaying up the ramp.
Is it common protocol to run a boat's license number on vessels that have an expired registration?
I can if I want to double check that it is actually expired, which typically I would do that if you could provide some type of registration that would prove that it wasn't. That's when that would run the number through lien to see if it actually was expired. And that if it wasn't expired, then we'd go through other avenues such as failing to display the new decal.
Okay, so would you admit that you're trained to notice out-of-date registration stickers on boats and off-road vehicles?
Yes, sir.
Is it safe to say that you likely noticed my out-of-date registration when we were actually launching our boat right next to you?
Well, we noticed your registration. Well, the other officers did, notified us of it, and then we went to the scene, observed that you were the the driver that they stated was driving, that you were the vessel that had the expired registration, everything matched, that we had the correct vessel that was pointed out by other officers. And that's when we docked next to you.
No,
Yes,
we launched. So that day, Mr. Bourgeois, that day I launched my boat right next to you guys launching into the water around 2:00. Is that correct?
not that I'm aware of.
Okay, so when I was swimming with my family out in the lake and you guys rolled by us very slowly with no other boats around and waved at us, you didn't notice my registration then?
Well, so there was probably 10-ish officers. It probably wasn't me because I don't recall. And if that was you, sir, obviously we would have.
Yes, you answered that question.
Okay.
Is there a safety measure in place for officers to be sure that they're not encountering Native Americans on the water as they do not need registration? How do you approach that situation?
Well, sir, we treat everybody as if they're state fishermen or recreation. Once we make contact with the individual and they advise us that they are tribal, depending on what treaty they're in your case, the Sioux tribe and the 1836 treaty, we do have the jurisdiction to still check that you have everything that you're required by your tribe and continue a check. And if you don't have the stuff that you need, so say you're spearing, you have to have special permits that the tribe notifies.
Did you search my vessel that day to check and see if I had the required stuff?
No, sir, because you weren't in the act of fishing. You were driving the boat just down up the river.
So you didn't search my boat to see if there was any equipment that could indicate that I was fishing?
No, sir, because it's not applicable to the violation.
You didn't search. So you didn't search my boat, is that correct?
No, sir.
Do you have any evidence that at the time I was operating the vessel that my BAC was over the legal limit?
I had probable cause to believe that you were intoxicated upon the arrest.
That's not what I asked. Do you have any evidence?
Well, Mr. McLeod, that's not even relevant to the question here today.
Well, this whole thing is irrelevant. I mean, it's all based on hearsay and what these lying cops are talking about.
Well, this is a motion about whether the results of the blood test are admissible. So if you could direct your questions toward that question.
You say you obtained a warrant to draw my blood. That's correct?
Yes, sir.
Why wasn't I shown or given a copy of the warrant upon release?
Myself and Officer Listenfeldts actually left copies with the jail, as the prosecutor stated earlier. That's why they weren't sent by me to the prosecutor. I have the affidavit and the search warrant right next to me. I believe they made copies, or at least we left the return and tabulation, which you're required to by law. So that was left for you at the jail by us, and Officer Listenfeldts could testify this as well. But everything, all legal processes were covered by us at the jail.
Is it common procedure to not sign an affidavit that goes with the warrant?
I'm sorry, what do you mean by that? All my affidavits are all signed.
I'd like to submit exhibits from my motion to suppress. Exhibit 4, all 3 pages of exhibit 4 into evidence.
That's the warrant.
It's well, I didn't have a copy of the warrant. It's just unsigned documents that are supposed to be accompanying the warrant.
So exhibit 4 to your motion was it says warrant felony, and then it's got the signature page with no signature and the return that's not filled out.
Yeah, and actually exhibit 3 also, the affidavit of probable cause is unsigned.
Okay, the affidavit of probable cause exhibit 3. All right, and that's the 2 pages. Any objection to the admissions of those pages? We'll mark it as defendants A. No objection. All right, take the list and mark it as defendants A. All right, that'll be admitted. I'm sorry. All right, so those documents are admitted into evidence, Mr. McLeod. Can you redirect? No. All right, thank you, Officer Bourgeois.
Thank you.
Further testimony needed from him today?
No.
What's that?
I don't understand.
You don't understand either? Okay. And that motion is denied. It's legally nonsense.
So all this proceed.
And Mr. McLeod, you're filing, I mean, I'm letting you represent yourself, and you're filing motions that you're telling me today you don't even understand. That's not a very responsible way to proceed. There's also a motion to recognize your subrogation rights. I have no idea what you're talking about. Do you? Can you explain it to me?
It's not necessary.
That motion is denied. It again is legal nonsense. All right, the time for motions has come and gone.
I don't consent to that.
Well, you don't have to consent to that. I gave you a motion cutoff. All the motions have been denied. Now is the time, Mr. McLeod, where you have the constitutional right for a jury trial. So I can set this trial for, would 2 days suffice, Mr. Julia?
I think we could probably do it in one day.
All right, well, just to be safe, we'll schedule it for 2 days then. I can schedule this for a jury trial, Mr. McLeod, on Thursday, Friday, August 8th and 9th. And what we'll do is we'll be here Thursday, August 8th to select the jury. And then we'll go immediately into the trial. As needed, we can, we'll continue into Friday. I'll have you both file witness and exhibit lists within 21 days of today's date. Also, I'm going to have you file, any side that wants to, I mean, the people have to, if you want to, you can as well, proposed jury instructions by 21 days from today.
Motion to stay the court while I leave to bring this into the Western District Federal Court where it's supposed to be held. There's questions that you're answering and having opinions on that you don't have the jurisdiction to have answers. I brought that up in several motions and keep claiming that you do. It's clearly written in the consent decree that you don't.
It's manifestly untrue, Mr. McLeod. I mean, the consent decree doesn't mean that you can drive around on a boat drunk. And if the police catch you doing that, that comes in state court. It doesn't come in federal court.
Aren't you supposed to be an unbiased participant?
I am unbiased. You may not have been drunk. That will be for the jury to decide. I'm just saying I have jurisdiction over that allegation. It's not a federal.
You're interpreting the fact that you're trying to say that I was supposed to notify him that I'm Native American, and that's not true. And that's your interpretation. You're having an opinion.
All right, that's fine. And if I'm wrong, another court can tell me that I'm wrong.
Motion to stay the court so I can take this to the proper court for an opinion on what you're trying to have an opinion on that you're not on that.
Denied. You can go to that court, and if they stay it, they'll stay it.
Okay.
So what we're going to do is we're going to have within 21 days of today, both sides will file jury instructions and witness lists and exhibit lists for trial. We're going to come back for a docket call on May 28th at 9:30 in the morning in person here in the courtroom. And jury trial is scheduled for August 8th and 9th. Anything else today, Mr. McLeod?
That's fine.
All right, argument on the motion to suppress the chemical test results, Mr. McLeod?
Well, I've already shown that the warrant's invalid. It's got unsigned documents that are supposed to be accompanying it. So I would say that it should be upheld that this warrant was invalid. It was executed improperly. It was not served on me. It was not given to me by release. It was not found in discovery with 3 requests. So it's very convenient that it turned up Friday.
All right, thank you, Mr. Juliet.
Just briefly, just based on, I understand the court has to make a credibility assessment here on whether the officer did in fact type up a search warrant and serve it on the defendant. He certainly had probable cause to draw blood. That's common procedure when somebody refuses a chemical test. The defendant displayed signs of intoxication, which led to the arrest for voting under the influence. He refused a chemical test when offered one. Based on the observations of the officer, he had probable cause to submit for a search warrant for blood. He did that. He typed out the affidavit, and it looks like, to me, it looks like it's electronically signed. On defendant's exhibit 3, he said that he served it on the defendant, left it in jail. So I would ask the court to deny the defendant's motion.
All right, well, the motion was to suppress the results of the blood test for alcohol in Mr. McLeod's body because the blood was drawn without a warrant. Based upon the officer's testimony in People's Exhibit 1, that blood was in fact taken pursuant to a search warrant issued by a magistrate. So therefore it didn't violate the Fourth Amendment. The complaint and affidavit and warrant that the defendant's referring to are the charging documents for the issuance of the charge. That doesn't have anything to do with the drawing of the blood. There was a warrant for the drawing of the blood, and it was drawn. And the officers testified that they did leave the warrant and tabulation and affidavit at the jail for him. Whether that got to him or not is frankly immaterial. Even if it didn't, that doesn't invalidate the action of drawing the blood. That would violate the Fourth Amendment if it was done without a warrant, but it was done with a warrant. So that motion is denied. Mr. McLeod, you also have a motion to dismiss on procedural grounds for a probable cause conference not being timely held or validly waived. Any additional argument you want to make on that motion?
Yeah, the waiver was supposed to be signed by both parties. That's state law, and only the prosecuting attorney signed it. And then neither my defense attorneys or myself signed it. I'm just curious how that transpired.
Hey, Mr. Juliet?
Just briefly, I did submit a response to this, and I did research the case law on this. I did confer with district court. It doesn't look like a probable cause conference was held, but I did read the case cited by the defendant in his motion that dealt with the failure to hold a preliminary examination within the statutory time period. That doesn't warrant dismissing the case. If anything, that would call for a remand, perhaps, to district court.
Remand back to district court.
But in this case, and in the case that I cited, there has to be some showing of prejudice by not holding the preliminary exam or probable cause conference by analogy. In this case, there was a preliminary exam that was held and it was bound over by Judge Visnot. So I don't think there can be any prejudice by failing to hold a probable cause conference.
All right, yeah, Mr. McLeod, the purpose of the probable cause conference is to see whether somebody wants to run the prelim or waive the prelim to address any bond issues. You were already free. You weren't being held in jail, and you did run the prelim. So there's, even if a probable cause conference wasn't held, there's no
probable cause conference could have stopped a lot of those procedures because the probable cause is all hearsay.
No. But see, probable cause conference, the prosecutor doesn't have to prove probable cause at that hearing. They have to prove it at the prelim. The probable cause conference, it's maybe not a great name for it, but that conference is just to address, are we running a prelim? What issues might there be at the prelim? Should the defendant be released from the jail pending the prelim?
But does it not still need to be waived by both parties?
It does, but the fact that it didn't has no prejudice to you. So defendant moves to dismiss the case on the ground the probable cause conference was not timely held and that it was not validly waived.
Actually,
I'm making my ruling now, Mr. McLeod. Defendant relies on People v. Weston involving the failure to timely hold a preliminary examination for an in-custody defendant. His reliance is misplaced, however. In People v. Crawford, the Michigan Supreme Court held that the Weston remedy must be invoked prior to the preliminary examination being held. In any event, Weston did not address probable cause conference, which did not exist at the time. The probable cause conference is to address possible plea negotiations, bond matters, and the scheduling of the preliminary examination. Defendant has shown no prejudice, even if a probable cause conference was never held and not validly waived. Moreover, defendant exercised his right to the preliminary examination. Dismissal is an extreme remedy, and defendant has not shown that it is warranted. Accordingly, his motion to dismiss is denied.
You say exercise my right to preliminary. Wasn't that kind of a forced situation under duress and threat of arrest?
It's your right to have a prelim, and you exercised it. So you exercised a right, and it was held. So there's no harm to you. You exercised a right. All right. Now you filed a second motion to suppress based on lack of sufficient basis for law enforcement officer to make contact. I'm not entertaining oral argument on that motion. It's just a repeat motion. Defendant moves to suppress evidence and dismiss the case based on a lack of sufficient basis for the law enforcement officer to make contact with him and a lack of evidence of his intoxication or impairment. This motion essentially raises issues that were argued in defendant's first motion to suppress. As explained previously, the officer had legitimate grounds to approach defendant based upon his observation of defendant operating a marine vessel with expired registration. Upon initial contact, the officer detected signs of impairment. Therefore, both his initial contact and his investigation were entirely lawful. Accordingly, defendant's second motion to suppress is denied. Mr. McLeod, you also filed a motion to reconsider the reconsideration. That's not really authorized in the court rules. I'm not entertaining oral argument on that. Defendant moves for reconsideration of this court's recent order denying his motion to reconsider this court's denial of his motion to suppress evidence for an allegedly illegal police contact. As the moving party, Defendant bears the burden of demonstrating a palpable error by which the court and the parties have been misled, and that a different disposition must result from correction of the error. Moreover, a motion for reconsideration which merely presents the same issues ruled on by the court, either expressly or by reasonable implication, will not be granted. Defendant essentially raises the same issues that have already been briefed and argued. Defendant has failed to meet its burden of demonstrating a palpable error. Accordingly, the motion for reconsideration is denied.
I think you're failing to notice or recognize the lack of jurisdiction that you have in this.
Well, that brings us to you filed 3 more things, and I want to address those today because today was the motion cutoff. So you've got a motion.
And I don't consent to that anymore either. I need more time to file these motions.
Nope. No, today's the motion cutoff. You filed 3 more. I'm going to hear them today. You have a motion for dismiss for lack of jurisdiction. We've addressed the jurisdiction previously.
You don't have jurisdiction.
I already ruled that I did. This motion,
have your own jurisdiction.
this motion is denied. This court does indeed have subject matter jurisdiction over the charges by law and personal
jurisdiction. I object.
Your objection is noted and your motion is denied. All right, you filed a motion for disclosure of bonds. I don't even understand what you're talking about.
I don't know. Somebody else handled that.
In this hearing, the judge carefully reviewed a series of motions filed by the self-represented defendant, who argued that law enforcement lacked authority to stop him and that the blood evidence against him should be suppressed. The defendant also claimed that tribal membership protections, procedural errors, and jurisdictional issues required the case to be dismissed. However, the judge found that officers had lawful grounds to approach the defendant due to an expired boat registration and that signs of impairment observed during the encounter justified the subsequent investigation. The court further ruled that the blood draw was conducted pursuant to a valid search warrant, making the evidence admissible under the Fourth Amendment. Multiple additional motions were denied because the judge determined they either repeated previously rejected arguments, lacked legal merit, or failed to demonstrate any prejudice to the defendant's rights. Throughout the proceeding, the judge emphasized that disagreements with prior rulings did not eliminate the court's jurisdiction and reminded the defendant that unsupported allegations could not replace valid legal arguments. The hearing concluded with all pending motions denied and the case scheduled for a jury trial, where factual disputes regarding the defendant's alleged intoxication will ultimately be decided.